for a referendum. Problem is their full court, the Supreme Court, said there was. So this judge is outranked. But look at what they did in the second schedule to the Supreme Court Act. The second schedule was amended by deleting our sovereign lady, Queen Elizabeth II, her heirs and successors, and inserting said state of West Australia. Well, isn't this turning the hourglass of tenant-landlord over? Suddenly the tenants become the owner. But I mean, you'd put $1.5 million into that block of flats. You collected rent for a while. And suddenly all the tenants got together and said, we own the joint, you can rack off. I said, well, how are you going to transfer the title? Oh, actually, we got that arranged down the titles office. Is that what's happening here? Well, is that whatever you want to call it? I mean, I'm only a farmer, I'm not legally trained. But when you drive a tractor around a paddock for a lot of hours, you think a lot. And you get out and you ride it on a bit of dirt there, and then the next round you plough it up. But you remember the bit you wrote. Well, that's part of all this. As in, how could they do that? What do they intend to do? What are they substituting it with? All those questions come around your head. And then you look at your little kids or whatever the kids and you think, do they know? Do they care? Does the adult know? Does the adult care? First off, we could conclusively prove the adult doesn't care, but has the adult had the overview? First off, they've got to get the overview, which means that's in a courtroom. That's the only place you have to prove the point. And all you're really saying to the other side is, pull your chair up to that side, ring the bell. Impartial umpire. I was considering wearing my rugby jumper tonight, because I love it. Impartial umpire, boundary lines, lines people, two opposing forces, sin bin and a blood bin, very parallel with Christianity. But the critical part is impartial umpire. And in this case, the only impartial umpire is a jury. Anything halting that or suppressing that is attempting to pervert the course of justice. Look what they've done. Threw her out and put themselves in. Royal assent jurisdiction. Now, after the Australia Act, and I think I conclusively proved there's a big question mark in there. Commonwealth Constitution, Section 58, Royal assent to bills. When a proposed law passed by both houses of Parliament is presented to the Governor-General for the Queen's assent, he shall declare according to this discretion, but subject to this Constitution. Well, this Constitution means they're all subject to it, including all state constitutions. This is the Supreme Constitution. Now, they've mucked around with it. They'll even say Section 58 is gone. Problem is, you needed a referendum to take it out of there. That he assents in the Queen's name, or that he withholds assent, or that he reserves the law for the Queen's pleasure. So that after the Australia Act, the Royal Assent capacities passed to the Governor-General, Governors and Premiers without needing to do all the other stuff, purportedly. The problem is, if the Australia Act proves to have legal flaws in it, it's not valid. Therefore, you're assuming an unlawful authority. And that's why the title of this is Unlawful Government. They're taking wages illegally because they're tricking the owner. Australia Act 1986. Now that's the best, that's conclusive proof, that one. This Act, or this section, amends two sections of the West Australian Constitution, and that's the following sections. Section 50, and the next slide please, and Section 51. Now, do you remember the 6 sections protected for state electorate consent? It's Section 2, 3, 4, 50, 51 and 73. Suddenly we've got 2 of the 6. So did you see it at the Australia Act? Did you see it at the Australia Act? You're the jury. So, sitting as a jury, would you say the Australia Act valid or invalid?
Invalid.
Now, if it's invalid, do the governors, Governor-General and Premiers then have the correct authority after the Australia Act?
No.
And do they then have the authority to sit in the West Australian State Parliament now?
No.
You're the jury. Are they allowed to go back there?
No.
We're Christians. We're Christians. Can they repent?
Yes.
This is the grace we offer. This is the grace we offer, which is have the jury trial with a 1-month amnesty. That is the grace of a trial of the issue. That's fair. It's also grace.
Is there enough time for them to do it?
The correct bell will be rung by God. Don't worry, be a good timekeeper. That's a very good book, that. I can't even pronounce the name. I assume it's called Chameleon Crown by Anne Toomey. Now, who's Anne Toomey? Professor of law. So she knows what she's writing about. And McHugh even wrote the foreword in this. McHugh's a High Court judge, saying in the foreword, I wish we had known what's in this book before we did some judgments. Well, hello. What's that saying?
Too late.
Not necessarily. And look at what she's saying at page 261 of this book, which I would suggest you try to get because it's going to become a very valuable book. It says this: Section 13 and 14 amend provisions in the Queensland and West Australian Constitution Acts, which had entrenched the role of British ministers and the use of British seals in the appointment of governors and making of royal instructions to governors. Listen to the next few words. These states sought to avoid referendum on the subject for fear that it might not be successful.
That's right.
A big statement by the Professor of Law. Big statement. Next one, please. At page 261, she's talking about legislative power. The Queensland and West Australian governments considered that only sections 13 and 14 of the Australia Act 1986 UK were effective to amend the state constitutions, and that the Commonwealth did not have sufficient legislative power, they're big words, to enact sections 13 and 14 of the Australia Act 1986. These provisions were included in the latter Act to ensure the consistency of the two Acts. Some states were doubtful about the validity. Well, I wonder why. I wonder why. Of some of the provisions in the Australia Act, but took the view that as long as at least one version of each provision was valid, that was sufficient. It's about to get tested in the fire of the electorate. The West Australian Constitution, section 73(2). A bill expressly or implicitly provides for the abolition of or alteration in the office of Governor. Now, did the Australia Act change the office of the Governor?
Yes.
Did the Acts Amendment Repeal Courts and Legal Practice Act change the office of the Governor?
Yes.
Well, he replaced the Majesty and put himself there. That's an alteration. Expressly or implicitly provides for the abolition of Legislative Council, Legislative Assembly. Or, C, expressly or implicitly provides that the Legislative Council, Legislative Assembly shall be composed of members other than members chosen directly by the people. D, expressly or implicitly provides for a reduction in the numbers of the members of the Legislative Council, Legislative Assembly. Probably that's where the Marquette matter ran into trouble. E, expressly or implicitly in any way affects any of the following sections of this Act, namely 2, 3, 4, 50, 51 and 73. Shall not be presented. They're big words. Which means don't go any further with that bill. Stop right there. You've all had to prattle about it. Now you've got to take it to a couple of conditions. The second and third readings of the bill shall have been passed with the concurrence of an absolute majority of the whole number of the members for the time being of the Legislative Council and Legislative Assembly. The bill has also, prior to such presentation, been approved by the electors. Two conditions: absolute majority, and it's got to go to the electors. Did they fulfil either?
No.
Did they fulfil both? You're the jury. How are we doing?